Lord, I have 5 submissions to make. The first relates to the temporality of Article 370 and its interpretation, and how it impacts on CO 272 and 273. My second related proposition is that mandatory provisions of the Constitution are not defeasible and cannot be derogated from. The third is, my Lord, the basic structure argument, which has 2 aspects, my Lord. Firstly, basic structure is a constitutional limitation. This is not the argument we wish to advance. That is, if there is an amendment, basic structure will apply. That's the constitutional limitation. What we emphasize is basic structure as a principle to be applied by all authorities, and especially the courts. The fourth, my Lord, argument is the location of sovereignty and the constituent power
location of sovereignty in the constituent power.
No, my Lord, the location of the substitution of a statehood, my Lord.
Sorry, the fourth one.
Sorry, my Lord.
How did you begin the fourth proposition? I perhaps didn't take it correctly.
The sovereignty proposition, my Lord.
Yes. How do you begin? Did you say location of sovereignty or?
My Lord, I'll explain that when I come.
No, but just as a head, what would you like us to take?
Broadly speaking, my Lord, the argument is this: that generic, basic sovereignty lies with the people. To operate this, there is sovereignty which is external in nature in terms of international law. That is, no other state can make you a vassal state or have any power over you. And the third, my Lord, is after the Constitution has been enacted, where does the constituent power lie? On which Mr. Dwivedi had a few things to say. And the fifth argument, my Lord, is the substitution of statehood by union territory, on which I want to cite just one section of the Reorganization Act. What I propose to do, my Lord, is this: that as far as the citations I want to give, I put them on a piece of paper. I think they've been uploaded. I'll hand it over to your Lordships, so that your Lordships doesn't have to scribble. I think you've done enough scribbling for quite some time. So, my Lord, let's come to the first question of temporality. We've done our share of scribbling too, my Lord. Let's come to the question of temporality, because that goes to the real issue before your court, Lordship's court. What does temporary mean in 370? The Chief Justice pointed out that when you contrast it with 269, where it says 5 years, therefore certain conditionalities have to be met. If those conditionalities are met, then at that particular point in time, the temporariness goes. Now, what were the conditionalities, my lord, that were available as far as 370 is concerned? There were two sets of powers in 370, which were assigned to the Constituent Assembly. The first power was to reject the constitution-making process completely. That is 370 subclause 3. This is a power that the Constituent Assembly did not exercise. CO 44. CO 44, my lord, where this power was used, it did not exercise this power to abrogate the constitution process completely. The second, my lord, conditionality was to fulfill its task of making a constitution. This task was fulfilled in 1956 and came into effect on the 26th of January, 1957. So both temporalities, my lord, exhausted themselves in 1957. After that, my lord, 370 ceases to be a temporary provision. I'm not saying cease, which has been argued on this side by one council, that it ceases to exist. I'm saying it ceases to be a temporary provision. In my respectful submission, what follows is that it becomes a special provision of the Constitution, like 371A, all the schedules, etc. So 370 would be read, my lord, as a special provision, just like the other special provisions that you find in 371A onwards, or the many provisions that you find giving autonomy in the 6th schedule, which is such a vast schedule of autonomy, because by this time, autonomy was attained by the JK Constitution. Now, my lord, there was what kind of federalism is this, my lord? It's an example of cooperative federalism. Where two powerful democratic forces meet and decide on the fate of a particular area of the Constitution. One powerful democratic force came from the people of Jammu and Kashmir themselves in the antecedent discussions, as well as through the Constituent Assembly. That is, a powerful democratic movement had to be taken into account. The second, my lord, is democracy had to be preserved as part of cooperative federalism. Hence, to make it a balanced cooperative federalism, we find the words concurrence, consultation, recommend. These are methods of cooperation in a cooperative federalism. And they're writ large in the 6th schedule as well, my lord. I've taken your lordship through that. I won't do it again. Now, my lord, the argument on the other side is that it remained temporary for 60 odd years. Lord, that argument is almost a farce. If a constitution has continued for such a long period of time and been used as such for a long period of time, you can't say it remains a temporary provision. What is left of 370 is just 370 subclause 1. Because 370 subclause 2 and subclause 3 are dependent on interaction with the Constituent Assembly. This is a mandatory provision which is indefeasible. Therefore, my lord, when I say a special provision survives, my lord, in the spirit of cooperative federalism, it is 370 subclause 1. The rest, my lord, because the Constituent Assembly has completed both its tasks or conditionalities, one in not going the non-constitutional route or going the constitutional route as the case may be, nothing survives in 370 subclause 2 and 3. Nor is it possible in 370 subclause 3 to argue a doctrine of substitutability. That for Constituent Assembly, you can substitute legislature. Nor, and on that I'll give a note on what the proviso says, my lord. The proviso, my lord, has a symbiotic relationship with the main provision of 270 subclause 3. Now, some arguments were made, my lord, and I must, because I don't know whether they were made frivolously, that 370 is a compromise. If, my lord, 370 is a compromise, you'll find compromises right throughout the Constitution. Take, for example, Article 25. Sikhs are allowed to carry their daggers. You want to get rid of that, my lord? You have to have a constitutional amendment. This is a compromise. The entire 6th schedule is a compromise. But the most important compromise of all concerned the privy purses. It's a compromise between 271 and 362. They said, all right, you've surrendered everything. By way of compromise, we give you a privy purse. And what do the two judgments, my lord, on these two say? Maharaja Scindia is clear, along with the other judgment, to say, if you want to take this compromise away, then you must amend the Constitution. Therefore, any compromises that are there in the Constitution, my lord, follows from a very important insight, my lord, of Fali Nariman's, that if today we were asked to make a constitution, we would not succeed. It's in one book of mine published 2 years ago, but that's a different matter. Israel was never able to come to terms with getting constitution through because it could not evolve by compromise anywhere. New Zealand did not initially have a constitution of its own. It couldn't come to terms. So as far as compromises are concerned, they are writ large across. That is the process of constitution making, to accommodate the largest number of views and come to a compromise. And that is borne out, my lord, by the princely persons cases. That was a compromise. We'll give you your princely purse. And when they tried to change it by definition, Maharaja Scindia, the first Maharaja Scindia, my lord, said, sorry, by definition, you cannot change it. This is, in fact, a compromise which is embedded in the Constitution 271 and 362. It is only after the amendment was made that the compromise was set aside as a part of the constituent power. Now, my lord, I want to test this particular argument. One argument has been made, my lord, with the second argument that I want to advance is non-derogability of mandatory provisions. And then we will test this against 272 and 273. There is no doctrine of necessity in our constitution, my lord. There is a doctrine of constitutionality, but no independent doctrine of necessity. It is about the most dangerous addition that one can make to any constitutional process, where you say, because of necessity, we could not follow your mandatory provisions. Your lordships have held that even directory provisions must be complied with to the extent possible, but we're not there now. We're on the question of mandatory provisions. Now, as far as 272 and 273 are concerned, my lord, one argument that I want to enlarge on the basis of what Mr. Gopal Subramanian said, my lord, kindly have a look at 152. This, I won't give the dates again because these dates have been given by Mr. Subramanian. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Therefore, as far as the entire part is concerned, this constitution recognized the relevant provisions relating to the states, legislature and otherwise, my lord, and incorporated those provisions after, my lord, 238, etc., was done away with, as my lord the Chief Justice pointed out. Otherwise, there would have been a vacuum. How was that vacuum filled? By reference to the JK Constitution and those relevant parts of the JK Constitution itself. Then, my lord, if your lordships will kindly come to 308. (308), my lord, is part 14 of the Constitution, which deals with services under the Union and states. All this, of course, has been done away with, my lord, now, without amendment by the Reorganization Act. It says in this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. This, my lord, would be a vacuum, but for the fact that the constitution makers were aware that provisions relating to these two parts relating to 152 and 308, were already there in the Jammu and Kashmir Constitution, and in fact, as far as these are concerned, they were incorporated by implication into the Indian Constitution. Now, my lord, on the basis of this, let us just test 272 and 273. My lord, there's another aspect, my lord, and our small argument was made that the preamble doesn't contain socialism and secularism. It's actually there in the Jammu and Kashmir Constitution. I'll just give your lordships the sections. No, just give me my black volume. First, my lord, kindly come to section 13. This is volume 2, PDF 20. I'll just read it out, my lord. There's no point, your lordship, Otherwise, I'll dream of PDFs all my life, my lord. I don't want to do that. Now, my lord, 13 says, state to establish a socialist order of society for the promotion and welfare of the people. Long before it came into the Indian Constitution, what was the necessity of amending the preamble? Then, my lord, if your lordships would kindly come to section 20, compulsory education. The JK Constitution says compulsory education in certain cases and reflects those educational provisions in the directive principles. And the third, my lord, is section 25, the state of duty of the state to foster equality and secularism. So it was no great omission, my lord, as far as the JK Constitution was concerned, as has been pointed out. Now, my lord, let us come to 272 and 273. Bearing in mind that mandatory provisions of the Constitution are not defeasible. My second proposition. Now, my lord, one thing that I forgot to mention when I mentioned 152 and 309 of the Constitution that says it shall not apply to Jammu and Kashmir is it was done by this amendment of the Constitution in the 7th Amendment. Therefore, if any change had to be made, it could only have been done by the constitutional amendment and not otherwise. With this, let me read, my lord, CO 273 first. None of the conditionalities of 3C70 and subclause 1 are met here. It says, in exercise of the powers of clause 3 of the President of India on the recommendation of Parliament. Where does Parliament come in, my lord? The body in question, according to the original Constitution, is Constituent Assembly, and according to 272 is the Legislative Assembly. Where is the question of Parliament coming in as a double substitution, which is there in 272 and 273? But let me just read on. All provisions of the Constitution, as amended from time to time, without modification or exception, shall apply to the Jammu, notwithstanding anything contrary to Article 152 and 308. Those are the provisions, my lord, where the Constitution, 7th Amendment, said that these provisions will not apply to Jammu and Kashmir. Is it possible, my lord, within an exercise of power under 370 to amend provisions of the Constitution or not? Because this was the stumbling block, my lord, in their way. The answer is they have not, my lord. Of course, as far as the conditionalities are concerned, none of them are met. There is neither concurrence, no consultation, no recommendation. It just says on the recommendation of Parliament. Where does Parliament come into this? Therefore, my lord, 273 is an amending provision well beyond the scope of Article 370. And not only is it amending, my lord, it also goes further to destroy any other article of the Constitution or any provision of the Jammu Constitution of Jammu and Kashmir, any law, document, judgment, ordinance, order by law, rule, regulation, notification, custom, usage, having the force of law in the territory, or any other instrument. Well, this is an amendment and actually an abrogation of 370 itself. That power having gone, if we agree that 373 has gone because the Constituent Assembly cannot be substituted. So the argument that Mr. Sibal made and was just made by Mr. Zafar Shah is there are two entities here. Two entities who are part of cooperative federalism. They have to interact. And the interaction is there in Article 370 and is entirely and totally missing from 273. If 273 falls, my lord, there will be a revival of 152 and 308. There has to be, because they are not, you cannot amend the Constitution which has actually been amended by the 7th Amendment. Now let's come to 272. This begins, my lord, by saying, in the exercise of power under clause 1, bear in mind, my lord, the exercise in 273 is under 373, which in our view has actually disappeared. Now I'm going to show its reappearance in another form. In exercise of the powers under clause 1 of 370, the President, with the concurrence of the government of Jammu and Kashmir, is pleased to admit. Now, my lord, if your lordship were to see the main provision of 367, subclause C says, references to the government of the state shall be constituted as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Therefore, my lord, when they say in concurrence with the government of the state, it has to be on the basis of the advice of the Council of Ministers. Therefore, there is a contradiction here between the interpretation clause and the opening clause of 272. This too is draconian because all the provisions, my lord, which are relatable, it just wipes them out completely without following any mandatory procedure. Now, what is the saving grace, my lord, that is provided here? And that is in D. In the proviso of clause 3, Article 70 of the Constitution, the expression Constituent Assembly referred to in clause 2 shall be read as Legislative Assembly. Here there is a double substitution according to them. Firstly, the Constituent Assembly is replaced by the Legislative Assembly. They're not on par, my lord. They're simply not on par. The Legislative Assembly, this idea that both had legislative and concurrent powers, constitutive powers, that is true of the Constituent Assembly of the Indian Constitution. There's a whole set of debates dealing with the legislative powers. As also, my lord, of the Jammu and Kashmir Constitution. So can such a substitution take place? Now comes the double substitution which we see in 273. Instead of the Legislative Assembly of the state, we get Parliament. So these provisions now involve a double substitution contrary to 373, contrary to 272, and we now move from the provisions, my lord, of recommendation under 370 concurrence, which is of course completely missing, my lord. Mr. Zafar Shah has pointed this out. I don't want to elaborate it. Totally and completely missing. The arena of cooperative federalism is entirely and totally missing. But can you have a double constitution substitution in this way, my lord? And that is to say that 367, the added clause is that the references to the government of the state shall be construed as references including the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. This is what the new interpretation is. You didn't act on the advice of anybody. You just said here that concurrence of the government of the state. Now, according to 367 itself, it means with the Council of Ministers. That is a mandatory provision. So, my lord, 272 and 273 are overbroad in violation of mandatory provisions of the Constitution. And shift the entire concurrence or consultation provisions or recommendation provisions from the authorities of Jammu and Kashmir to Parliament. This is the double substitution argument that they have advanced. Now, my lord, we come to the interesting part, my lord, of Article 3. Article 3 has a mandatory provision. I put that in my original submission, my lord, from 1960 onwards, that you must circulate any bill or change, the reorganization of, you must circulate it to that legislature. This is a mandatory provision. It is true that your lordships have also held, and those references are there in my original submission, that the centre is not bound by all your recommendations and subsequent changes can take place. But this does not take away from the fact that Article 3 is a mandatory provision. Now they say, as far as this is concerned, under Article 356, there is a power, my lord, to make incidental provisions that are necessary and desirable. And they say that one of the provisions that was made was that Article 3 will not apply. That is in not the President's proclamation of 19th December. Effectively, that's what it says. These provisions will not apply. It can't be done, my lord. President's rule, under President's rule, you do not have the power to do away with a mandatory provision of the Constitution. Now, my lords, I want to point out one thing, my lord, to your lordships, if I may. About the Reorganization Act, my lord. I just want to read one provision to your lordships, my lord. And that is Section 73. This is, my lord, Volume 3, PDF 112 at 130. I'll read it out, my lord.
Just repeat that, Mr. Dhawan.
Volume 3, 12 and 130.
Volume 3, PDF 112, where it starts, my lord.
Documents file?
The Reorganization Act. And I'm reading Section 73, which is at PDF 130. If the President, on a receipt from the Lieutenant Governor of the Union Territory of Jammu and Kashmir or otherwise, is satisfied that a situation has arisen in which the administration of the Union Territory cannot be carried out in accordance with the provisions of the Constitution. That is the same as 356. Now look at the next clause. That for the proper administration of Union Territory of Jammu and Kashmir, it is necessary or expedient to do so. This is also, my lord, there in Article 239A B. So we've added one more section to it, that if you think it is not expedient, the president may suspend all operations. The more important thing in section 73 is it has no time clause. So today, my lord, when your lordship asks for a roadmap, today the Constitution, my lord, that the president's rule that survives is under section 73. Unlimited time when it is expedient and necessary to do so. Necessary or expedient to do so. Lord, this is the core of the problem when your lordship asks for a roadmap. They are unable to give one. They too are, in a sense, are arguing that the Reorganization Act is in fact transitional in nature. A time will come when statehood will be restored. This is no roadmap at all, my lord. It is entirely and totally illusory. What is not illusory is the continuance of president's rule under section 73. This goes to the core of the governance, my lord, and the relationship of cooperative federalism. I want to make one more further point, my lord, on mandatory provisions. Although, my lord, there are several occasions when 370 has been used under president's rule, I'm going to make the broad argument, my lord, whether it was challenged or not is irrelevant, that when there is president's rule and cooperative federalism under Article 370 cannot apply, then 370 cannot be used at all. Because the mandatory provisions, my lord, require concurrence, consultation, recommendation. If these are absent and president rule, because of some suspensive order, gets rid of it, my lord, in no president's rule can be applied, my lord, 370. Because the very foundation of 370 would disappear by an exercise of a CO. So these are my first two propositions, my lord. Now I go to the third one. I'll have something to say in the proviso, my lord. What I've done is I've called out the authorities that I want to rely on, which I'll hand over, rather than your lordships, my lord, be troubled. And that is, my lord, relates to the basic structure doctrine. It is not the case of anybody that the basic structure doctrine applies in this case as a constitutional limitation. Nobody has argued that, my lord, and it cannot be so. But what the basic structure doctrine has been applied as is as a principle of the Constitution. Now, in Nagaraj, my lord, and I'll point out those two paragraphs. This is volume 19. PDF 164 at PDF 195. And kindly bear in mind, my lord, that in Bomai there was no constitutional amendment involved. And there are many provisions of that nature. There the principle, my lord, of the basic structure was applied. It is our respectful view that if democracy, federalism, reasonableness is given the go-by, then it would follow, my lord, the principles of these underlying these basic structure formulations will necessarily, my lord, guide your lordships in the exercise of any constitutional power. Now, my lord, I'm just going to read two passages from Nagaraj. I've given your lordships, my lord. The citation is 2006 8 SCC 212, which your lordships will find in volume 19, PDF 164 at 195. Has your lordship got that one? Para 24. The point which is important to be noted is that the principles of federalism, socialism, secularism, and kindly bear one more thing in mind, reasonableness and socialism are beyond the words of any particular provision. They are systematic and structural principles underlying and connecting various provisions of the Constitution. They give coherence to the Constitution. They make the Constitution an organic whole. They are part of the constitutional law, even if they are not expressly stated in the form of rules. Now, in Nagaraj, they defended the constitutional amendments, but subject to certain conditionalities that were imposed. And they said the identity of equality is not taken away, but you will follow these guidelines. Now, my lord, kindly come to the bottom of that page, that is para 26, next to placetum G. Overarching and informing of these rights and values is a principle of human dignity under German basic law. Similarly, secularism is a principle which is an overarching principle of several rights and values under the Indian Constitution. Therefore, axioms like secularism, democracy, reasonableness has been elevated to a part of the basic structure. Apply that to 272 and 273, my lord, and the answer will become clear. Social justice are overarching principles which provide linking factors for the principle of fundamental rights. These principles are beyond the amending power. They pervade all enacting laws, and they stand at the pinnacle of the hierarchy of constitutional values. It is our case, my lord, that the basic structure applies not as a constitutional limitation, but as a set of overarching principles which are part of the Constitution. Now I get back to my argument, my lord. It is idle to say that when my lord the Chief Justice used the word asymmetric, it was used in any casual sense. That is NCT 2. I said that it is a multi-symmetrical constitution, which I've shown to your lordships. And there is a violation of the multi-symmetric provisions of the Constitution as far as this exercise of 272, 273, and 370 is concerned. Otherwise, my lord, the whole Constitution would become meaningless. Bomai is a classic example, my lord, of where there is no amendment whatsoever, but you apply the principles. And there, of course, there are a host of others. Therefore, my respectful submission to your lordships, my lord, is basic structure is a statement of principle, applies in this particular case, though not as a constitutional limitation. Because I'm equally allergic, my lord, to the idea of going beyond the amendment process as far as constitutional limitation is concerned. I'm allergic to that particular idea. Constitutional limitations have their limitations in 368, provided there is an amendment. But there are also principles that are violated, and to that they have not provided any answer. Now I'm on the question of sovereignty, my lord. Anything more to be said? Now, my lord, I come to the question of the location of sovereignty in the Indian Constitution. Now, my lord, sovereignty has one meaning in international law. That is, you are not under any other country. To that extent, my lord, there is, as my Lord Justice Khanna pointed out, across the board, nobody has argued that the Indian Constitution is not sovereign and that Article 1 does not apply across the board. That is nobody's case. But I'd earlier made a distinction between external sovereignty
And internal sovereignty.
and, my lord, internal sovereignty. Now, I think internal sovereignty, my lord, is a bit of a misnomer. It really means the application of sovereignty in the distribution of powers. I'm amending that to that extent. Therefore, my lord, how is sovereignty to be exercised is what one means by internal sovereignty. It's the exercise of sovereignty distributed throughout the Constitution. Mr. Dwivedi has made some arguments, my lord, that there are many provisions of the Constitution that says this will not be an amendment to the Constitution. I've got, my lord, passages from Keshavanand. They were aware of these provisions, and they regarded this provision simply to mean you don't have to follow the procedure of 368 and nothing more than that. The constitutive power, sovereign power, exists in 368 and in no other provision of the Constitution. Otherwise, we'll be saying, my lord, that when the Constitution is, that you can amend the Constitution for the next 2 years, that during that interregnum, it's a constitutive power. And finally, my lord, I come to my last point, my lord, which is the substitution of statehood by union territory. My lord, the Constitution actually divides itself into two halves. A federation of states is one part of it. And the second part of it, my lord, are what could be called devolutionary provisions. That is union territories. Now, England, for example, my lord, Northern Ireland, my lord, has a lot to do with that since I taught there at Queen's, is a devolved provision. Wales is a devolution provision, so is Scotland. Whether they will be removed or not, my lord, is within the gift of the supreme power of Parliament. That is a different matter altogether. What has happened is that statehood has been taken away completely. Therefore, as part of the federation, union territories are not part of the federation of states. They are devolutionary units which can always be taken away. And that is a fundamental distinction, my lord, recognized in all constitutional jurisprudence between, my lord, a federation and a devolutionary power. Now, my lord, I'll just hand over that note to your lordships, if I may. I think it's been put up as well. Just give me one copy. So that your lordship doesn't have to take down references, etc. My lord, the first is in relation. Has it been handed over, my lord? I think it's been uploaded as well. Huh? As a note on rejoinder, my lord. On proviso, my lord, the classic description of a proviso was given by Justice Fazazali in Sundaram Pillai. We need not multiply authorities after authorities on this point.
That part, it's a classical judgment on, it's a classical judgment.
That's right, my lord. But what it says, it may entirely change the very intendment of the constitution by insisting on certain mandatory conditions. In order to make it workable. Now, this, my lord, Mr. Gopal Shankar Narayan tells me, has been approved in Manohar Lal's case. Your lordship may just note that, my lord. Constitution Bench 220, 8 SCC 129 at para 193. At para 193.
Read the citation, please.
Over the page, my lord, I won't take your lordship's 2020 Constitution Bench. Your lordship is familiar with these provisions, my lord. That's why I don't want to read all of it. And over the page, my lord, I've given two further examples of the proviso as a condition precedent. That is, Edwinson, State of Assam, where consultations had to be taken with the board, or Narayan Das, my lord, where consultations had to be taken. And this is a condition precedent. Now I come to, my lord, on the application of the basic structure doctrine as a principle of interpretation of the Constitution. Bomai, my lord, is my first example. I've given your lordships the paragraphs and the PDFs. In Kolo, my lord, and across the board, use was made of basic structure as a set of principles. Once again, I've given that at 3.2. As regards interpreting 301 and 304 Jindal, the government of NCT versus Union of India, my lord, while interpreting the proviso to 239 AA4, and over the page I've reproduced from the second NCT judgment, my lord, because it's in my written submission, but I just reproduced that paragraph. I don't need to read it. These are all principles that have been applied across the board in interpreting statutes as well, and in certainly as far as constitutional provisions are concerned. Now, my lord, the argument that was advanced was that there are other provisions that by Mr. Rakesh Trivedi, which say this will not be deemed to be an amendment of the Constitution. In Keshwanand, my lord, the lordships were aware of this. For example, Justice Hegde and Mukherjee, amendments under 4, 169, 7 of the 5th schedule, para 21 of the 6th schedule, need not comply in the form and manner prescribed under Article 368. So, my lord, it is not that they are a part of the constituent power. They need not comply with the provisions of 368. The same, my lord, is set for Justice Palekar, who once again notes these provisions. I won't read that, my lord, because the point is there. Then Justice Matthew, my lord, who says enactments under 4.169, para 7, 5th schedule, para 21, are effected by ordinary lawmaking procedure, which is different from the procedure under Article 368. They're not rigid, they're not an ancillary constitutional power. They are, in fact, special provisions which don't require the invocation of 368. And then, my lord, there is Justice Beg and Justice Chandrachud. My lord, that's all I have to say. Now, my lord, what is the reliefs that we are seeking? If we stay within, my lord, a very narrow circle, then Mr. Sibal is right. So all your lordships have to adjudicate is the temporality of 370, 272, CO 272, 273, and whether mandatory provisions are defeasible. That is all that is before your lordships. The antecedent speeches, so many have been quoted, my lord, in the list of dates, are totally and completely irrelevant. Because as soon as 370 is born, that is the provision which is the incorporating provision, and there is no other. You don't even have to refer to Gopal Swami Iyengar's provisions.
Thank you, Mr. Dhawan.
I'm obliged.
Thank you, Dr. Dhawan.